All righty
Here.
then. All right, good morning, members of the Bi-County Subcommittee of the Prince George's House Delegation. I don't know if we have any non-members that are with us. I'm looking to see. We have a couple of folks that are with us. With that said, for those that are joining us and are not members of our subcommittee, I'll repeat myself weekly. These are subcommittee meetings. They are not hearings. Public testimony was welcome during our public bill hearings a couple of months ago. And I want to be clear that it has come to my understanding, we had received several calls in my office anyway. I don't know about everybody else, but that, as I said, these are just hearings. We had received a couple of messages and calls saying, well, that we did things differently this session. This is not different. I think some subcommittees run it a little differently and allow everyone to speak. The vice chair and I do not do that. Folks will be called upon if needed, if there are questions from the members of the subcommittee. So with that said, again, we only have one piece of legislation on our docket this morning, which is PGMC 10724, which is, sorry?
I thought it was 106. I'm sorry.
Which is the Prince George's County District Council Community Benefits Agreement Authorization, the Community Empowerment Act. And I know it is also the vice chair and my understanding that the bill sponsor, I don't see her on here though.
I just sent her a message.
Okay. So for the members, Delegate Alston would like to share some updated information. Pardon?
I'm sorry. I'm going to send her the link. She said she didn't have the link. So just give
okay.
a few minutes.
Right. So just letting the members know she will be coming before us to have an update on the status of her legislation.
Yeah.
Madam Chair, may I clarify that you are saying that it's 107 and not 106, correct? For this.
Well, according to my, it's the right. Yeah, it says
it's 106.
Oh, this piece of paper I have says 107. So I apologize. 106.
All right. Okay, this is taking me a little longer. Hold on. I'm working on it. I'm going to get it to her. Let me see how I can. There we go.
So, Anne, you want to mirror your image because your background looks backwards.
Oh, yours looks backwards to me.
Really?
Yep.
Okay, so
mine looks right on because mine's already on the mirror image.
I thought mine was on mirror because I'm looking at it and it looks right to me. Well, that's weird.
Maybe you need to flip it the other way because both of you are
both of us are backwards. Okay. Well,
all right. I'll deal with that another time.
I'll try it. Let's see what happens.
Okay.
Is that better? Okay, let's see.
Has Delegate Alston joined us?
Yes, she has.
Okay, so again, for the members here, Delegate Alston is getting her steps in and would like to.
Thank you. Yes. Good morning.
Good morning. So the floor is yours, Delegate Alston.
Okay. So the bill has multiple amendments, which I believe as of last night, they were still being worked on. Is Shane on the phone? Has he went through the bill already? And I just need to talk about purpose and how it will work in practice.
No.
You're muted,
okay.
Madam Chair.
All right. So
you're on mute, Madam Chair. Sorry.
Oh, sorry. Delegate Alston, would you like our counsel to explain the amendments before you go into further discussion?
I think that would be helpful.
Okay, great.
Sure, I can do that. I'll try to be as brief as I can, but there isn't a really great way to shorten some of this. So
I'd rather you not be so brief because this is the only piece of legislation we have on the docket.
Sure,
just
understood.
Yeah.
Okay. If I may, I'll just read through the bill summary as it currently exists, and then I'll go through the amendments. Is that okay? So at present, the bill in its current form affects only Prince George's County. Same with the amendments. But the current bill specifies that the authority of the county planning board specified that the authority of the county planning board over zoning and subdivision matters is not exclusive and subject to review and final action by the district council. Additionally, the district council may adopt and amend zoning law procedures for zoning decisions by the county planning board and district council. Within the regional district in the county, any zoning power granted to the planning commission or board of appeals under certain provisions of the law must be construed as vested exclusively in and may be exercised only by the district council. The bill also alters certain standing requirements in certain zoning matters, as well as remand procedures for certain zoning matters that have been appealed. The bill also requires certain approvals as specified in the bill to expire at a certain time. And finally, it prohibits the district council from amending the zoning laws or zoning classification of property that is currently used or was formerly used as an airport in order to allow construction of multifamily residential dwellings on the property. So with the amendments, several changes have been made. The amendments specify that the Prince George's County Planning Board no longer has exclusive jurisdiction over certain matters, but rather just jurisdiction. Those matters include local functions such as the administration of subdivision regulations, the preparation and adoption of recommendations to the district council with respect to zoning map amendments, detailed site plans, comprehensive design plans, and specific design plans, and the assignment of street names and house numbers in the regional district, as well as certain mandatory referrals that are specified in law. Additionally, the amendments alter the parties that may seek judicial review of a final decision of the district council. They also require that a reviewing court conduct judicial review of a district council decision in a certain manner, and any party to the proceeding in circuit court may appeal the final judgment to the circuit court. May appeal the final judgment of the circuit court to the appellate court of Maryland. Also, a member of the district council may not vote on whether the district council appeals a decision to the appellate court if the member recused themselves from participating in the hearing on the matter or in the decision previously. Uncodified language is added by the amendment that clarifies that certain provisions of the amendments are meant to abrogate the holding in the Supreme Court of Maryland decision, Prince George's County versus Zimmer Development Company, which is a 2015 case. And then finally, the amendments strike language that is already in the bill, authorizing district council to adopt and amend zoning law procedures and decisions for the planning board and district council, as well as language that specifies certain zoning powers granted to the planning board or board of appeals. That language was previously drafted to be construed as vested exclusively in the district council. And it also strikes language that originally in the bill, regarding which parties may seek judicial review. I should also mention that we weren't able to run a reprint of this bill, like with the interlineated version with the amendments, as a result of the bill not being introduced. So that's like a drafting sort of mechanic. But now that it is, I'll be able to send that out once we have the amendments finalized.
Delegate, thank you, Shane. Delegate Alston.
Thank you. Good morning. Okay, so that was a mouthful. I don't know if you all would like me to just start with questions, if anyone has burning questions, or just go ahead and sort of talk through my purpose. What's the pleasure of the chair and the body?
Well, let's see. Do any members have any questions right now? Seeing none. Vice Chair?
I think that it might be great, since we do have time, to talk about the purpose, the intent of the bill, and what it is that you're trying to get at. And I think that may help if there are any questions, and particularly as it relates to some of the amendments.
Okay, great. Thank you for that. So, can you hear me okay?
Yes.
Thank you for that, Madam Vice Chair. Okay, so the purpose of the bill is to empower our district council and our residents to make sure that when land use and zoning decisions are being made, they're being made by the people that we have elected to do so, in consultation or with the advice of the Park and Planning Commission. What has happened since the Zimmer case has been a situation that I personally find untenable. The district council will make the Park and Planning Board will make a decision. Sometimes, a lot of times, most of the times, district council agrees with those decisions. There are times, however, when district council disagrees with those decisions, and when district council has disagreed with those, and then it goes up on appeal, the court is enforcing the planning board's decision instead of the district council's decision. And I believe that this is because there is confusion in how the court should be reviewing it. When we elect people to district council, we're electing them with the understanding that they will have the authority over land use and zoning decisions. But since the Zimmer case, that authority has been vested within park and planning, so that they are the ones that have the authority to make these decisions, and district council has to be beholden to their decisions. And I don't believe that's what the voters of our county intend when we elect our district council members. And so by changing the manner in which the court can review these issues and giving original jurisdiction to the district council is strengthening the power of the district council to make sure that when they make a decision, that their decision is the one that the court has to review for legality. Was their decision arbitrary or capricious? Was their decision a complete violation of law? Was there a mistake or fraud or irregularity? And if it was not any of those things, then the court must uphold the district council's decision, and they cannot substitute their opinion for that of the district council. And what's been happening is that the court has been reviewing district council as the appellate body to park and planning. And so when the members that we elect to do this work say, we don't think this is the right decision, the courts are saying, well, you can't substitute your opinion, district council, for the opinion of park and planning. And so this is clearly a political decision that we have to make. This was the case pre-Zimmer. The district council had this power. It was not an issue. It was not a problem. And our county thrived and did well. And at that time, we were the #1 county for African Americans in the country. And that has changed. And I think we need to re-empower our district council to make these decisions. So that's the first thing. And that's the overarching purpose of the whole entire bill, is to make sure that we are getting quality development, that our elected officials can review and make decisions on, because we put these people in those positions and empower them to make those decisions. And we need to respect that role and that fact. The other issue is that sometimes, well, let me stop there because that was a mouthful, and see if there are any questions about that piece before I go to other parts of the bill.
I just want to clarify a point, because I'm pretty sure I know the answer, but because I've never served on the council, and God bless all of you who have. Having said that, when we say district council, that's still the county council, right? They just have a different, it's our
Yes.
county council who we elect in, but, so I've always had a question about that, because when people, and I'm just saying, people, those who run for county council, that they would also, anyway, you know what, I'm going to keep my comment to myself. Having said that.
You froze, or did I freeze? I can't hear.
You froze, Madam Chair, but you're okay now.
Okay, the internet in this place is so crappy. Anyway, having said that, what is the percentage of time that you stated that there are times where park and planning, or the court will go with park and planning's opinion over the district council? How, because it's my understanding that this has been the way that things run now for a long time. What is the percentage of time that you felt it was needed to revamp this, that it has happened where the court goes with park and planning's?
I would have to check with the zoning council person at the county level. So I'll get that information to get the actual numbers. I think that it's just been the cases that they've done this with have been probably some of the most recognizable cases. So I will get the data for you so that you can receive it. I believe our vice chair probably has more real life lived experience with this, as she was on the council when this bad decision came down. And I know that they have been working hard to try and reverse some of the effects of it since it happened. So I don't know if she might have more illuminating information.
Okay, and then my last question, well, for now, would be, so you stated that the reason for you bringing this forth is primarily because of this, what has been happening on and off on occasion of the decision of the courts going towards park and plan. My question would be, so as I read the bill or have read the bill, how is it that we would allow our constituents or constituents in our county who have no, there's no negative impact on them since they don't reside in the district of which a proposed project would be coming to, that they would be permitted to stop a project and it's not even in their district? I'm trying to understand it.
That's a great question, and I think that may be some
So
confusion.
if you can put in a different perspective, that would help me understand it.
Okay, great. I can definitely do that. So I think there's some confusion when it comes to, are we both talking? Can you hear me okay? Okay. So when it comes to constituents being able to ask for review or appeal, the way that happens is, number one, you would have to register as a party of record with Park and Planning at the first stage. So when the property is posted and that little orange sign is out there, you call the number or you go online and you register as a party of record. Anyone can do that. Once you're registered as a party of record, then you get all of the information. You can take your concerns to Park and Planning as well as the district council. The next phase is if you do not like the decision that comes from district council, Park and Planning and or district council. Well, it would have to be district council because they're the final decider. If you don't like that decision, then you can go to court under certain circumstances. So those circumstances are, do you have standing? And the standing laws, it used to be almost anybody could do it. Then it was like, no, you have to actually be affected, meaning that your property basically needed to touch the property that was being changed or altered or wherever this development was taking place. What my bill does is it says if you live, I believe it's a 1 mile radius is what the bill says. So if you live within 1 mile of the impacted area, then you can become a person of record. You will have standing. You can't become a person of record, I'm sorry. You would have standing to file for review in court. And the reason that is important is because not all of the parts of our county are urban. Some parts are very rural. And so, and where I live, it takes 1 mile to get off of my street to the main road. So by using, it takes actually over a mile. But by saying within 1 mile, what you're saying is once you get to the main road, if there's development that's taking place, I'm absolutely going to be affected by what's happening. And I think most people, if it's something within 1 mile of where they live, most people would generally agree that they are affected, whether it's traffic flow, crime, educational facilities. A 1 mile radius is a very small area. We can walk a mile, right? And so if it's that 1 mile radius, what we're saying is then you have standing. So this does not apply if you live in Fort Washington and the development is taking place in Capitol Heights, you would not have standing to then go in and try and file a lawsuit in court to stop that development. But if you live in Capitol Heights and you're within 1 mile of the proposed development, then you would be able to go to court and seek redress.
Okay, thank you for that. I just want to remind members, we do have in the event you may have inquiries, we do have counsel from Maryland Park and Planning with us should you need their assistance. And those who are joining know that they are here merely for observation, and it's, as they know, it's not a hearing. So I just want to remind the members they are here for your resource. Vice Chair, I think you were about to say something. Or oh, I thought you raised your hand. I apologize.
No, I
thought,
didn't.
okay.
But I think that my light just went out. I think that it would be, because we're talking about Park and Planning, it would be great to hear from Park and Planning on this issue, if that's up to, if that's okay with you, Madam Chair.
Sure. You're the Vice Chair. You can seek who, okay. We have Council Deborah Borden with us. Good morning.
Morning, and thank you so much, Chair Valderrama, and Vice Chair Harrison, for the opportunity to answer any questions you might have. I do want to just say a few words about the bill in general and sort of the purpose. You know, I get it. I'm a zoning attorney. This is what I've been doing for 30 years. I understand that decisions that come out of the planning board sometimes are very controversial. They're sometimes, you know, just not what the community wants in that location. I understand. I've been on the firing line of that. So what I can tell you though is the way that zoning is done in this state is designed to deal with that, is designed with that in mind. Okay, so the district council has been set up by the state to write the zone, well, enact the zoning laws, approve the zoning laws, right? So they approve the use table. They approve the map that shows where the zoning districts are and which properties are part of different zoning districts. They do the high level approval that is legislative in character, and they do that with lots of input from the community. We generally do it by master planning, and then we do a comprehensive zoning, and the ultimate arbiter of that is the district council. They do that. They are the legislative piece of this puzzle. So they put all of these pieces into place. And then when an individual property owner comes in and says, okay, I want to build my building, they have to file something called a site plan. And what is a site plan? It's just a plan of their physical development. It says the building goes here, the parking goes there, you know, the building is this high. That's all a site plan is. A site plan is not a referendum on the use. The use has already been determined years before. Okay. So a site plan comes in, and where does that go? That goes to the administrative agency that is there to deal with these details, because it's like hundreds of details, right? That they have to check off and make sure that that is in conformance with the regulations, the myriad of regulations that apply to building a project in the county. Now, should the district council be doing that? I don't think so. And I don't think they really want to do that, because that would take up a lot of their time. And they're supposed to be legislating. They're supposed to be doing the macro look. They're not supposed to be doing does Deborah want, 3 windows or 4 windows on her house? That's not what they're supposed to be doing. So that's why you give that to an administrative agency. And every county in the state does that. They give those details go to an administrative agency, because that's just little stuff, right? But it doesn't appear to be little stuff, because when you have a neighbor who has a building that's going up next door to them and they don't like it, that's a big deal to them. And they want action, they want results, they want that to be denied. But if it can't be denied because it's in conformance with all the rules and regulations and the use table, then it can't be denied. I mean, that decision making has already occurred. And so what can they do? They can go to their council member and they can say, you know what, this was a mistake. You guys really should do a better job when you do the next master plan, because this didn't work out so well. And so you do it within the master plan system. Is it perfect? No. Does it make everybody happy? Absolutely not. But what the planning board does is they follow the law. They can't be pilloried for following the law. I mean, they are anyway, but in the light of day, as long as they followed the law, they're doing their job. And to suggest that they don't listen to the community, of course they listen to the community, but sometimes the community is talking about things that's not within the planning board's purview. It's not up to the planning board to say that use shouldn't have been that on the use table, and therefore we're going to deny the site plan because we don't like the use there. They can't do that. And here's the kicker. Neither can the district council. The district council, even if they were given this power to review all site plans and say yes or no, if the district council did that and said, well, you know what, the use table says you can go forward, but we're going to deny your site plan because we don't like it there, they would be violating the law. And so you know, this issue seems to be a fundamental problem with how zoning is done in the state. But the problem is this is not going to solve that problem. Okay, this, you know, if you don't like the way zoning is done in the state, you know, that's a much higher level discussion that's not going to be solved by taking away the word exclusive and muddying the water as to what the district council now can do as opposed to what they can't do. Because here's the thing, the planning board will still be an administrative agency. The courts will still look at them as the finder of fact, because otherwise, what are they for, right? And then after that is always a review on the law. That's the way administrative law works in Maryland. It's always going to be, you have a finder of fact, and then you have a review on the law after that. You don't keep finding the facts. You don't keep opening the record and adding stuff to it at every level of review. That is not the way it works, ever, in the state. So again, you know, these issues are always issues that are discussed. I understand that people want what they want. And especially when you're talking about their neighborhoods, they are really passionate about what comes into the neighborhood and what it looks like and how it impacts, you know, their lives. And that's important. But we're not going to basically change the, you know, the whole state law system because of that. We have to look for other ways to deal with that. Thank you.
Thank you. Thank you, Ms. Borden. Members, Delegate Olson, I saw your hand, but I would like to give the members time here for their questions. Vice Chair Harrison and then Delegate Healy.
Thank you. So, Ms. Borden, we appreciate the explanation. I know that for some of us, you know, we understand how the process works, and some of your explanation is for the public so that they understand how things work. I think I would just take one bit of, I don't know if disagreement is the right word, but when you talked about, you know, how things work in the state in the appellate process, that is what we're here for. So, so to say that we can't make that change, and I don't know if you meant it in that way, but that's how it came across. That's what we're here to do. If we find a problem, then we're here to try to rectify that. So I would just take a little bit of exception to that part of your explanation, but I appreciate explaining how basically development works. And it's not an overnight process. And that's one of the things that I really like to try and explain. It takes years and years and years and years before, you know, when you see something come out of the ground, it started probably 5 to 6, 7, and sometimes even 10 years before you actually see what comes out of the ground. And with that, that is how change or mistake, the argument for change or mistake can come about, whether it is from a resident or from, you know, another attorney or another developer, because we know that over time things change. There have been plans, I know specifically, that have been in the works, you know, for 20 years, plans 20 years. And then all of a sudden now there is something coming up, and it fits in that zoning category, and it can go there by law. But when you think about how the area has changed, that then falls under change, not so much mistake, but change. And so individuals ought to have that opportunity to make that appeal. But I have also seen where, you know, individuals have taken advantage of situations, and I can give a very clear example in the Woodmore Town Center. It was something I was ultimately intimately working with, and to have someone from Accokeek to come down and say that can't go there in my community, that's an issue, and I will never ever accept that. ever. And so, so I appreciate that. I'm just saying all that to say, to give some context, some real life context into both sides of the issue. And I think that, you know, this discussion is good and we may have to keep working and massaging it. But, you know, at some point there has to be a meeting of the minds so that no one entity, we need to just always make sure we have checks and balances. And it has seemed at times that you know, the scales of justice, so to speak, have been very unequal. And I think that that is the spirit of Delegate Austin's legislation. We may just need to figure out how to get it so that the scales are even. And that's just my diatribe there.
Thank you, Vice Chair, Delegate.
Thank you, Madam Chair, and thank you, Vice Chair, for that explanation as well. We all need to keep learning again and again. If we don't deal with this on an everyday basis, we sometimes forget some of the things that have happened in the past. My question is for Deborah Borden. Ms. Borden, you referenced, you know, statewide planning and zoning. Is this situation that we have now in Prince George's County, as a result of a court case a few years ago, different from the rest of the state? Or did that court case put us in line with the rest of the state?
I would say
Or
it put us
neither one.
well, I would say it put us in line with the rest of the state because all Zimmer said was that the planning board is making a decision based on the record that's before it. It is therefore the finder of fact. So
Okay, let me just make it real clear.
Mhm.
So is this process that we're talking about changing in this piece of legislation, is
Mhm.
this process in place in our neighboring counties? Is it the same in Anne Arundel County as it is in Prince George's County under current law?
It is generally the same, yes, in the sense that there's a legislature that writes the law and there's an administrative agency that implements. And
So that this structure is the same in Charles County, Anne
Mhm.
Arundel County, Howard County, outside of the Washington metropolitan area where,
Frederick County, yep.
yeah, where
Yes.
for a long time, park and planning was governed by a whole separate set of laws.
It still is.
Well, not too long ago, it was integrated into the state law on land use.
Yes.
And so it's not a separate title anymore. It's in the same part. I'm not an attorney, but I know I was on the committee, the Environment and Transportation Committee, when we adopted the new land use law for the state. And so that is where my question is, yeah, I know that we're still distinct as a different area, but we're not working under completely different rules as every place else.
No, so we have a section of the land use article, but the basic principles upon which zoning is founded is the same everywhere. It's the same.
Okay, that is essentially my question. I just wanted to understand it. Thank you very much.
Yes.
Thank you, Delegate Healy. I just want to let the members know, if you have not seen, we have the County Executive Administration staff with us as well. And again, a reminder to everyone who's joining us, this is not a hearing, and those who are observing are here just for that purpose, unless members here have inquiries to understand the issue at hand. And so that is why Ms. Warren was tapped on. I see you, Delegate Alston, and you are being called next. And I will say my question, I saw you not in opposition to the question that was stated by Delegate Healy to Ms. Bourne. So if you have the floor.
Thank you. I actually wanted to address, and I will get the research because I think the difference is we're the only people with a body like park and planning that is only in Prince George's and Montgomery County. So the system is not the same across the state. That's the first thing. But when it comes to, Ms. Borden mentioned something about all of the details in the finder of fact. One of the amendments actually deals with that, we took out the word exclusive. So Park and Planning will still be able to go through the process of looking at the plans, determining what makes sense, making their recommendation to District Council. And the amendment that we were working on last night that Shane got to me, he got to me yesterday or the day before, and I finally spoke to the drafter last night about it. We're still working through some of the details that address the concerns of Park and Planning, but the word exclusive has been removed. So now the District Council will not have to deal with all of the details of all of these plans. That will still be vested within Park and Planning. The difference is when District Council has a disagreement, whether it's a disagreement of law or fact, that they can then review it. And when a court reviews it, it's the District Council's decision that is under review and not the Park and Planning decision. So we're looking at the exclusivity and the original jurisdiction are what's getting at that. And the amendment that came back from our lawyers here at the state recommended that we do a de novo appeal so that on the occasion that District Council wants to review it, they can give the parties a new hearing, and that's what we're working out now. So I just wanted to add some clarity to that question, and I will get for Delegate Healy and the rest of the members of this committee how it's done in all of the other jurisdictions.
With that said, Delegate
I'll
Austin, so-
send that out.
okay, so thank you, based on what you just shared with us, so it sounds, to me that you're still working on this legislation. So when you get the
yeah.
information that you are working on, would you kindly share that with all parties and not just the members, just so that we can have a thorough discussion again, and that everyone is in the loop of what it is that you're clarifying and working on? With that
Yes,
said,
and
are
I did
you-
waive, just for the record, I did waive privilege. So I thought that committee staff, our delegation staff was sending that out to everybody, because the difficulty was because the bill had not been put in the hopper, they couldn't do the amendment. So the amendments that they were working on in draft form were coming to me. I waived privilege so that everybody could see it, so we could all get on the same page. It's not an easy issue. It's a complex issue, and so it's been taking a while. We've been working on it for months since the first hearing when Park and Planning raised their initial concerns, and when I heard from the council about the impact of having exclusive versus original or de novo review. So we have been working on it. I did waive privilege, and I think Shane mentioned earlier that now that the bill has been placed in the hopper, he can get us a clean copy that'll be much easier for all of us to read and understand.
Thank you. Are there any questions from the members of the subcommittee? I see none. Delegate Olson, if you don't mind, I was waiting for you if you had a request, but I already know that that is going to be. So I would like to suggest, given this thorough discussion, that we special order this bill for the following week to have you get all your ducks in a row, what have you. And when I was what I meant by, and if I wasn't clear, and I apologize, when I said all parties, I know this is not a hearing, but just for true discussion and working on the issue at hand. I was rarely referencing Park and Planning, the county, etc. So if you would be so inclined, that would be appreciative. And with that said, that would be my suggestion, that we special order the bill till the following week. If there's any questions or to the contrary, that is, if there could be a motion, or the second, that would be great.
I move that we hold the bill for further discussion.
Great. Thank you, Madam Vice Chair. And thank you, Delegate Alston, for clarifying. And to all those who have joined us, please know that we do take this issue seriously at hand, and there have been ongoing conversations, whether on Zoom or otherwise. Please feel free to reach out to Delegate Alston or the Vice Chair and I regarding this legislation or any other. We really are trying to work together and work on the best resolution. So with that said, having that been the only piece of legislation on the docket, if there's any other commentary or otherwise, I see no hands. I'll say that Bi County is adjourned for this morning and we will see each other next week.
All
Thank you
righty,
very much.
bye-bye.
Bye.
Thank you.